Kristine and I am an attorney at Pfizer, but I'm not here on behalf of Pfizer. I'm here on behalf of FPM, and that is the association that represents the research-based industry in Europe, and the members is about over 40 members of research-based pharmaceutical industry in Europe, plus the associations that represent this industry in the European countries. I wanted to give a little bit of the policy view of the research-based industry on this issue. So maybe to start a little bit about the context, to understand what we are talking about here. And I want to go back to the sector inquiry into the pharmaceutical sector. Actually recognized the strategic significance of the pharmaceutical sector in terms of the health, innovation, economic growth, employment. This is an important sector for Europe. They also pointed out the importance of IP and the protection of IP rights in that sector. They said in the report, the sector relies significantly on intellectual property rights, and intellectual property rights are a key element in the promotion of innovation. So why am I saying this? Because it is really important to understand why we rely so heavily on IP rights and why we get really upset when we can't enjoy the full exclusivity that is granted by these IP rights. It is a very long, complex, costly, risky process to bring a medicine to the market. It is a long process. It takes about 12 to 13 years between the moment that you file your patent and the moment that you can finally bring that molecule to the market. So there's only a limited period of time that is left for exclusivity in the market. It is costly, because for the R&D for every chemical and biological entity, it takes more than €1,000 to do that research. And it is very risky. On average, it's only one or two of every 10,000 substances that we synthesize in the laboratories to successfully go through all the phases and then come up with a marketable product. And even when we have a marketable product, it's only 20% of these drugs that make it to the market that will actually generate the profit that is necessary to subsidize new drugs. So this is why it is so important. If we don't have the right to exclude others from the use of our IP, even if it is during a limited time period, the pharma companies just will not have the massive investments that are needed to develop these new drugs and also cover the costs of all the failed projects. So the exclusivity periods that are granted through the patent law are really providing the incentive to the originator to continue innovation. That's why it is so important. And this is why we need legal certainty that the IP rights will be respected until the end of the expiry. Or if that cannot be, that there are at least effective options to defend and enforce our IP rights. Once the IP rights have expired, the generics can come on the market. And that's a good thing, because they will lower the cost of treatments and can contribute to the sustainability of health systems, and they free up budget by the governments for the innovative medicines. But so that means that we should have effective IP enforcement, and that's where the problem lies. In the current framework, in the current litigation framework in Europe, it is fragmented enforcement and it offers no effective means of protection. So IP disputes are litigated in multiple jurisdictions, and there is a real risk of divergent decisions by the diverse national courts. There's two elements that are important in enforcement of IP rights, and the first one is preliminary injunctions. So it is very difficult to obtain a preliminary injunction, and the conditions to obtain these injunctions are different in every country. Plus, member states in general are very reluctant to grant them unless there is an actual infringement, meaning unless the generic is already on the market, you're not going to get that injunction. And when the generic is on the market, you're faced with irreparable harm. So the governments, the courts in Europe are very reluctant to give this as a preventative measure. So we have to wait till the generic is on the market. And plus, even if you get a preliminary injunction, it takes a lot of time to obtain this in most courts. It can go up to more than a year before you get your injunction. Not very timely. The second thing is then, when you win a patent infringement suit on the merits, it is difficult to recover all the damages. Why? Because it's just difficult to prove and calculate what the damage is. How do you prove what your loss of sales and loss of profit is due to the entry into the market of that one specific generic? Especially in a market that is dynamic, the market conditions will change once the generic comes on the market. It's very difficult. It's almost a hypothetical question. Plus, obtaining damages is not always, or obtaining damages in the way of loss of sales and profit is not always accepted by the courts. Many courts just give you reasonable royalties or just the infringer's profit, which really doesn't cover all the damages for the originator. So we are left with irreparable harm. And once the generic comes on the market, it's there. You have a mandatory price cut, the reimbursement status will change, and even if the price changes, that will have a spillover effect to other countries due to international reference pricing. Other countries refer to the price of one country, so in these countries you see the price also going down. There's also inherent market changes. Once you have a generic, there can be guidelines for healthcare professionals to prescribe first a generic under the INN. The same thing for pharmacists. Maybe there's a substitution obligation. All of that is irreversible, even if the generic afterwards is taken off the market. You can never go back to the situation where before the generic came on, even if the generic came on the market infringing the patent. A possible remedy that the industry presented when during the time of the sector inquiry was an early resolution mechanism. The idea is to obtain the resolution of a dispute on your patent before the generic launch. That way you could create predictability for both parties, so this would be good for the generic and for the innovator, and it would reduce the need for settlements. So because of that irreparable harm, I saw so many people relieved, and now they have to listen to 2 more slides. Oh my God. Sorry about that. So because of the irreparable harm, this is why the companies are settling. So you see this economic and legal reality, that explains why there are these settlements. And regarding these settlements as an infringement by object, well, that is just wrong. If you look at the sector inquiry final report, it illustrates itself that where interim injunctions were granted, so where the originator has shown the likelihood of success on the merits, settlements, even with value transfer from the originator to the generic, were still typically entered into. So you can see that it has nothing to do with the validity, the value of a patent, or whether the patent suit would be won or not. The threat of a launch in other countries, and also the uncertainty of the litigation and obtaining damages in that litigation is that forces the originator to settle. So regarding, again, it's not a reflection of a weak patent, but it's about the relative bargaining powers, negotiating strengths of the parties, and of course the different perceptions of risk. It's a legitimate way to avoid costly litigation, and it's efficiency enhancing, especially in courts. A lot of the courts in Europe are suffering from backlog. So that's why settlement should not be seen as an infringement by object, which would generate huge uncertainty, and it would undermine the confidence in the patent system. So finally, this is the policy position of the innovative companies. We need a balanced competition policy. It's not because a settlement is favorable to the generic and contains a value transfer from the originator to the generic company that it would be an infringement by object, or that that it would have an anti-competitive effect. Competition enforcement cannot be based on the assumption of a weak or an invalid patent. If you do that, you fundamentally undermine the patent system, and it's exactly that which is a strong patent system which is needed to underpin the investments in research, which is needed to find these new medicines needed for the consumers, patients who are looking for new treatments. And it's not that we're putting all our money in the lawyers, because we give about the most in Europe on research and development. The number for last year was 30 billion in R&D. It's an important. This is our lifeblood. This is what we do. The role of competition authorities should be limited to these cases where the disputed patent has been obtained fraudulently, or where the settlements include restrictions that manifestly exceed the scope of the patent. And lastly, so if you look at the situation that I just outlined, any approach that would encourage and prolong patent litigation simply undermines the confidence in the patent system. And that is what is needed to encourage innovative manufacturers to make these investments that are necessary for the R&D of new drugs. It will therefore have a knock-on effect for patient welfare and also for economic growth. Thank you. That's our position.